And now I think we can, without a break, start with the first keynote lecture by Professor Tommaso Beggio from the University of Trento, who unfortunately wasn't able in the last minute to join us in person, but we shall at least hear his very interesting lecture online. And the subject is Capital Punishments and Forms of Deprivation of Freedom in Ancient Rome. Remarks on the influence of some Roman criminal law concepts on the Western legal tradition. Tommaso, the floor is yours.
So thank you. Thank you very much. Can you hear me?
Yes, yes, we can hear you.
Thank you, Nina. Thank you very much. Thank you. I would like to thank all the organizers of the conference, and I would like to thank Professor Avramovic, the Dean of the Faculty, Professor Polojak, who introduced this conference. I'm really grateful and really honored for this invitation, and so I'm really happy to have the opportunity to give this lecture before all of you. And of course, I apologize for not being there in person. I'm really sorry, but I had some duties and tasks at the university that I could, unfortunately, I could not postpone. In any case, thank you very much for this kind invitation. Well, I will begin with some brief premises. First of all, I decided to give to my lecture a very long title, so sorry for that. But I immediately wanted to stress the fact that some Roman criminal law concepts, and particularly some Roman criminal law concepts concerning capital punishments, have influenced the so-called Western legal tradition, contrary to the opinion of some Roman law scholars. So I will now move to different kind of methodological premises. The first one concerns the fact that Roman criminal law has been considered for a long time a residual field of Roman law. When Theodor Mommsen, the well-known German scholar, published in 1899 his popular, famous Römisches Strafrecht, he dealt with the topic of criminal law, of Roman criminal law, in an extensive way for the first time. Yet Mommsen considered that Roman jurists were giants in the field of private law, whereas they were not that skilled in the field of Roman criminal law. This kind of very authoritative opinion by Mommsen was then followed by many other scholars. Just to make an example, just to name one of the scholars, I could mention Francesco Carrara, a well-known penal law scholar, Italian penal law scholar, who defined the Romans giants as giants in the field of private law, whereas Francesco Carrara said that the Romans were pygmies in the field of criminal law. And Francesco Carrara's point of view was starkly, deeply influenced by Mommsen's opinion. Mommsen's opinion, as I told you before, influenced then the generations of Roman law scholars over the decades. And so Roman criminal law has always been considered somehow residual if compared to Roman private law. Of course, there has been great exceptions in the studies of Roman criminal law, just to mention but a few, Ernst Levy, Wolfgang Kunkel, and some other scholars. Yet Roman criminal law has always been considered a residual field in the field of Roman law. The second point concerns the role played by Roman criminal law in the so-called Western legal tradition. Due to the fact that Roman criminal law has been considered residual by many scholars over the decades, scholars have usually also denied the role that Roman criminal law played in the Western legal tradition. In this sense, of course, there is no continuity, there is no reception, there is no reception of Roman criminal law as it happened, for example, with Roman private law in the Western legal tradition. This is sure. Legal systems are completely different. So modern legal systems are completely different than the repressive system of the Romans. That's clear. Yet, if we don't focus only on the idea of continuity to underline the influence of legal system of the past on the Western legal tradition, we have to admit that some concepts deriving from Roman criminal law have deeply influenced the development of criminal law in the Western legal tradition. It's a methodological issue. If we want to find a continuity, of course, we have to neglect that there is continuity between the Roman repressive system and modern repressive systems. That's clear. But if we don't look for the continuity, and if we compare the legal reasonings, the concepts, the ideas behind some kinds of punishments and the repressive systems, we can find some similarities, or at least we can find an influence that Roman criminal law spread on the Western, the so-called Western legal tradition. A third point, then, I would like to stress before beginning with my lecture. The third point concerns the fact that Roman criminal law has often been studied as if the Romans had a kind of code, penal code, or criminal law code. So the dogmatic of many scholars to Roman criminal law, the approach of many scholars to Roman criminal law has often been very dogmatic. Yet Roman criminal law developed in a very alluvial way. So there was no clear system. There was no clear attempt to systematize Roman criminal law. The only attempts that we know are the attempts of some Roman jurists, like, for example, Ulpianus, Callistratus, Marcianus. Yet there is no system of Roman criminal law. And for this reason, it's really difficult to study the different institutions and concepts of Roman criminal law as if they were similar to our modern concepts. So these three premises that are partly methodological premises were necessary because I would like to deal, as the title of my presentation says, to the idea of capital punishments and forms of deprivation of freedom in ancient Rome, and how they, if and how they influenced the Western legal tradition. The main point I would like to focus to, indeed, concerns the idea of prison, of carcer. And I would like, therefore, to start by reading part of a text written by the Roman jurist Ulpianus, who lived between the second half of the 2nd century and the first half of the 3rd century AD, and the text is collected in the Digest of Justinian. I will read the small part of the text, and I try to share now the text with you. So let me check if I... Okay, can you see the
Yes,
text?
we can see it. Maybe you
Yes.
can zoom in a little bit, because I'm
Okay.
afraid people further away here won't see it.
Okay. Is it fine like that?
Yes, thank you.
Okay, thank you very much. So just a few lines of the third text that I mentioned in my handout. So it's a text taken by the book 9 of the Officio Proconsulis by Ulpianus, collected in the Digest 48, 1908, and the paragraph is the paragraph 9. The paragraph 9 concerns the carcer, the prison, and the text reads: Solent presides in carcere continendos damnare, autut in vinculis contineantur, sed ideos facere non oportet. Nam uius modi pene interdicte sunt, carcer enim ad continendos homines, non ad puniendos aberi debet. So if we want to try to translate the text, we could translate it as follows. So governors are in the habit of condemning men to be kept in prison or in chains, but they ought not to do this. In fact, punishments of this type are forbidden. Prison indeed to be employed for confining men, not for punishing them. Well, it's not my aim, of course, to analyze now in depth this text and to discuss the several problems of interpretation concerning the words written by the jurist Ulpian. Nevertheless, it is important to stress that this excerpt lies at the basis of a firm opinion consolidated by the scholars over the centuries, and this opinion that lasted in the Western societies until the 18th century AD, if not later, is an opinion which affirms that the Romans did not conceive the carcer, the prison, as a kind of punishment, but only as a preventive measure. Yet, I will say that if we want to try to understand whether prison played a role in ancient Rome as a kind of punishment, we have to move away our perspective from modern dogmatic concepts and try, as far as possible, to analyze the concept of capital punishments and the different forms of deprivation of freedom that the Romans applied at their times. By the way, of course, I am in general speaking of Roman law, but of course you know that Roman law developed over the centuries and over different eras. So the Roman law of the archaic period was not the Roman law of the Principate or the Roman law of the Dominatus. That's clear, of course. In any case, in Rome, the loss of liberty and the loss of citizenship as well, as a consequence of a punishment, was connected to the idea of capital punishment. Capital punishment did not only and necessarily meant death penalty for the Romans. Any kind of punishment that deprived a person either of citizenship or freedom, and in some cases eventually of life too, was to be considered a capital punishment. Any penalties that affected the person from a legal perspective through the so-called status permutatio, the change of status concerning either liberty or citizenship in this case, was thus to be conceived as a capital punishment. We find a definition of capital punishment in a couple of texts that I mentioned in my handout, like, for example, the text number 2, another text by the jurist Ulpianus, book 18 of the commentaries at the Dictum, digest 48/19 Principium, Rei capitalis damnatum sic cipere debemus ex qua causa damnato vel mors vel etiam civitatis amissio vel servitus contingit. That is to say that a capital case, a capital trial, a capital issue has to do either with the death or with the loss of citizenship or with the loss of freedom, of liberty. So the person becomes a slave, the convict becomes a slave. This is what the Romans conceived as capital punishment. Or, for example, I could quote the text number 5, written by Modestinus, another jurist of the time of the Severan dynasty. And Modestinus, in the book 8 Regularum of his work called Regule, collected in the digest book 50, 16, 103, licet capitalis latine loquentibus omnis causa existimationis videatur. Existimationis, that means that is a causa, that is a case that has to do with a change of status. Tamen appellatio capitalis mortis vela missionis civitatis intelligenda est. So Modestinus in this case stresses the fact that capital punishment, the capital trial, has to do either with the death of the convict or with the loss of citizenship, in this case, in this definition by Modestinus. Anyway, as I told you before, the Romans knew several different ways, several different forms of deprivation of citizenship or freedom, and in some case of life of the convicts. So, for example, an ancient rule already known in the 5th century BC, before Christ, punished harshly the so-called furtum manifestum, that is, the manifest theft. Under the 12 tables, the thief if a freeman could be enslaved by his victim and became an addictus, a person who had lost his freedom and belonged to the victim of the theft, whereas the thief, if a slave, could be simply executed. The manifest theft was considered particularly outrageous, and therefore the thief would have been subjected to the capital punishment. In early times, this person subjected to the person who was offended by the theft became an addictus, and the addictus lived in a situation comparable to slavery, even if this person was not definitely a slave. So he lived under a condition that was a kind of semi-servile condition. The case of the addictus was not the only peculiar case of archaic Rome, developed in the archaic Rome. So, for example, the sacertas was another harsh punishment for those guilty of parricidium. And the homo sacer, so the convict, was somehow removed from the society, was somehow removed from the social group he belonged to, and he was devoted to the gods in such a way that if he would have come back to Rome, to the social group he previously belonged to, he would have been killed. And the person who would have been killed, him or her, would not be guilty of murder. So these cases were very ancient kinds of punishment, typical of the archaic Rome, and they were substituted over the time. In the Republican times, we don't know any longer of the application of the sacertas or of the addictio, for example. Yet some other measures were developed and could lead to the loss of citizenship in the Roman Republic. In this sense, a very important role was played by the exile. Yet the history of exile in Rome is quite controversial, and many scholars have debated on the effects of this kind of punishment at the time of the Republic. The most ancient form of exile was the so-called aqua et igni interdictio. The aqua et igni interdictio was originally considered as an alternative to the death penalty, so the Roman citizen could escape the death penalty by going somewhere else, by leaving Rome and being exiled somewhere else. The Roman citizen under trial who feared to be condemned to death could therefore decide to leave the city of Rome before the condemnation was issued. In early times, the person who decided to leave Rome would not have lost either the freedom or citizenship. Yet, this person could not return to Rome. Otherwise, she or he would have been catched and executed. So the aqua et igni interdictio was a kind of privilege that represented an alternative to escape the punishment, more than a penalty in itself. Yet something changed in the 1st century BC, at the time of Sulla's dictatorship. In that period, after Sulla's reforms in the field of criminal law, the aqua et igni interdictio began to lead to the loss of citizenship, and the loss of citizenship was therefore a consequence of the aqua et igni interdictio. In any case, and for sure at the time when Cicero was consul, so 63 before Christ, a new form of punishment was introduced in the Roman system. This new form of punishment was the exilium. The exilium was different than the aqua et igni interdictio, because the exilium was a proper punishment, and the exilium was inflicted as a punishment and was not an alternative to the death penalty. So, in any case, both the aqua et igni interdictio after the reforms of Sulla and the exilium in the 1st century before Christ caused the loss of citizenship, and therefore they were a kind of capital punishment. Both these penalties, furthermore, led to the separation of the convict from the rest of the community. So if we have a look at capital punishments at the time of the Republic, we can say that on the one hand, we had, so the Romans could apply the death penalty. On the other hand, they could apply from the time of Sulla onwards the exilium, whereas the aquatini interdictio was an alternative to avoid, to escape the death penalty. This kind of picture, this kind of situation concerning capital punishment became more articulated at the time of the Principate, in particular from the time of Tiberius onwards. The capital punishments were then divided into two different groups from the time of Tiberius onwards. On the one hand, there were the punishments that caused the loss of citizenship. This kind of punishment led to what the Roman jurists called the peregrinitas. Whereas on the other hand, there were the punishments that provoked the loss of freedom and, in some cases, also the death of the convicts. These other punishments were grouped under the name of servitus penae, so the so-called slavery of punishment, what the Germans name Strafsklaverei. So, on the one hand, there was the peregrinitas, on the other hand, there was the servitus penae. Nonetheless, under the emperors, two different kinds of punishment became an inflicted punishment, the relegatio and the deportatio. And the deportatio was the only kind of punishment that led to the loss of citizenship of the convict. The relegatio was a form of exile from Rome, and the convict was obliged to live in a certain place, usually in Ireland, for a certain period of time. But the convict did not lose the citizenship. He or she only lost part of the estate that was confiscated by the imperial treasury. Anyway, the convict did not undergo a status permutatio and the capitis diminutio and conserved both freedom and citizenship. On the other hand, the person subjugated to the deportatio, which was a banishment to a particular place, often remote and harsh, it could be an island again, or in some cases an oasis in the desert, or places like that, so very remote from any city, any social group. The person subjugated to the deportatio lost great part of the patrimony that was confiscated by the imperial treasury, and more important, was not a Roman citizen any longer. The person of the convict was thus diminished from a later perspective. The convict underwent the capitis diminutio due to the loss of citizenship, and therefore the status of the convict changed. And by the way, the freedom of movement was heavily reduced. Of course, if it's not possible to completely compare the condition of a person condemned to the deportatio to the living conditions of a person condemned to prison in our days, it is nonetheless possible to find out already some similarities, some features that are common to both these kinds of penalties. Anyway, as I told you, at the time of the Principate, there was the peregrinitas, so connected to the deportatio, but there was also the servitus penae, connected to some other kind of punishments. So there were several penalties that subjugated the convict to a legal situation that led to a state of civil and juridical death, somehow followed by the physical destruction of the sentenced person. This kind of punishments were, for example, the different kinds of execution, for example, crucifixion, burning alive, beheading, and so on. But I would like to focus my attention on three particular punishments, so the damnatio ad metalla, the damnatio ad ludum, and the damnatio ad gladium. So what was the damnatio ad metalla? Generally speaking, it was the punishment to forced labor in the mines. The Roman jurist Callistratus wrote in a text that I quote in my handout. It is the, sorry, it is, yeah, the text number 4. So as Callistratus, the jurist Callistratus, wrote, proxima morti pena metalli coercitio. So the forced labor in the mines was to be considered proxima mortis, so a punishment very close to the death penalty. In any case, there were 3 different kinds of condemnations to forced labor in the mines, respectively called damnatio ad metalla, damnatio in opus metalli, and damnatio in ministerium metallicorum. The harshest penalty was the damnatio ad metalla, that was mainly conceived as a perpetual punishment, at least until the 3rd century AD, when the judges began to have the power to inflict this penalty also for a fixed period of time, according to the circumstances of the crime and according to the circumstances and the condition of the criminal. Because this was another principle that developed at the time of the Principate. So the penalties should not be necessarily fixed. The judges had some discretion in applying the penalties, and they should try to figure out what the most effective penalty was according to the conditions of the criminal. So penalties could vary according to the sex, according to the circumstances, according to the kind of crime. For example, if a crime was more often that took place more often in some provinces than in other provinces, the judge could punish harsher the criminal, and so on and so forth. And somehow, somewhere, judges were also influenced by local customs and local rules in some of the provinces of the empire. Anyway, the damnati ad metalla, so the convicts, the forced labor in the mines, were probably marked on their face. They were all chained, and the oldest convicts could barely see the light of the day because they had to descend into the belly, the depths of the earth, when the sun rose, and they came out only when the sun was already set. Their work was particularly harsh because they were charged with mining destruction activities. If they tried to escape, if there was a so-called prison break, and then the fugitives were captured, they were sentenced to death. The opus metalli was less severe than the damnatio metalla because the convicts were likely not branded on their faces, and even if all chained, the chains were lighter than the chains that oppressed the damnati ad metalla. The activities that the damnati in opus metalli had to fulfill were partly less harsh than the activities of the damnati ad metalla. The damnati in opus metalli, for example, had to process the minerals. The fugitives who were then captured were sentenced to the metalla, so from opus metalli to metalla. And so they became damnati ad metalla according to a scaling principle. At the bottom lay the damnatio ministerium metallicorum, that was the lesser of the punishment to forced labor in the mines, as the activities required were not as harsh as in the other 2 kinds of condemnations, and the needed physical strength to realize them was smaller. Women were usually condemned to the ministerium metallicorum, even if it was absolutely possible to sentence a man to this kind of punishment. Some of the activities that the damnati Ministerium Metallicorum had to fulfill were, for example, material handling and transport of the raw materials. So even if there were differences between these 3 kinds of punishments, we can easily recognize some common features. So the convicts lost their freedom. Even if the condemnation was not perpetual, but was for a fixed period of time, the convicts lost their freedom forever. The convicts suffered the social stigma called infamia, and they became servi pene. All the convicts were chained, and they had to leave where they worked. They spent almost the entire day in the mines or quarries, and they only had a few hours to eat and sleep. When they were not at work, they lived all together in the same place, at times chained. And this place where they had to stay when they did not work was called Custodia, quite similar to a prison. It was a kind of prison, well, used as a custody. So the case of the punishment to forced labor in the mines is particularly meaningful, not only because this penalty was the one more frequently inflicted to criminals of lower social extraction, but also for another reason. So if you think at the idea of prison that emerged in the 19th century, and if you think at the idea of capital punishment that developed at times in the Middle Ages, the idea of capital punishment was strongly connected to the idea of the forced labor in the mines. And when, for example, Jeremy Bentham defined the kind of imprisonment, and in addition, the forced labor, you can, of course, find some similarities with the condition, for example, of the damnati in opus metalli, not with the damnati ad metalla, but with the damnati in opus metalli. Of course, the damnationes ad metalla did not pursue any kind of reformation purpose, but only deterrence and retribution. And the damnati, as I told you before, lost their freedom once and forever. But still, they lived in a condition under custodia where it did not work, and then they had to fulfill this kind of forced labor in the mines. And this idea of forced labor in the mines has strongly influenced many legal scholars over the centuries. Just a couple of words now on the damnatio ad gladium and damnatio ad ludum. This kind of damnationes, of condemnations, were condemnations to fight as gladiators. There was a difference between the damnatio ad ludum and the damnatio ad gladium, and the difference was the following one. The damnatio ad ludum consisted in the condemnation to fight as a gladiator, but the gladiator could survive, of course, the fights in the arena, and could get somehow a kind of freedom, something similar to freedom, due to the will of the princeps of the emperor, if the princeps, the emperor, wanted to free the convict person from the condition of damnatus ad ludum. Anyway, the damnatus ad ludum was, in any case, a servus bene. So he actually lost freedom unless the princeps, the emperor, wanted to offer him a restitutio in integro. The damnatus ad gladium, so this other kind of convict person, was not simply condemned to fight as a gladiator in the arena, but, as we can argue from a text by Ulpian that I did not quote in my handout, the damnatus ad gladium had to die in 1 year from the time when the sentence, the judgment, was issued. So the damnatum ad gladium was forced to fight as a gladiator. Yet, if he did not die in the arena, he would have been sentenced to death after 1 year. So this was the main difference between these two kinds of punishment. Anyway, also the damnati ad ludum et ad gladium, where they were not in the arena fighting against other gladiators, had to live in the ludus, and the ludus was pretty similar to a prison. So to finish now this brief overview concerning ancient Rome, I would like to quickly come back to the idea of prison and its role in Rome. As I told you before, a firm opinion has developed, developed by many scholars, has been affirmed over the last decades and since the 19th century. And according to this opinion, prison in Rome could only have a preventive purpose and could not be a punishment per se in itself. Roman law scholars has somehow followed in this perspective the opinion expressed by Theodor Mommsen in his Römisches Strafrecht. And Mommsen's point of view, due to his authority, has influenced generations of scholars. Only in the last 3 decades, this kind of point of view has been questioned by some Romanist and legal historians. And indeed, the text by Ulpian that I quoted before, we can quickly come back to it. So it's the third text, paragraph 9. So solent presides in carcere, continendos damnare aut ut in vinculis contineantur, sed id eos facere non oportet, nam uius modi pena interdicte sunt carcer enim ad continendos homines non appuniendos haberi debet. So this text, that by the way presents several exegetical problems, anyway, can be interpreted as follows. First, it is addressed to the governors of the provinces. Second, the text recognizes that the governors of the provinces had a bad habit. And this fact means that actually prison was a punishment used in practice in the provinces. Third, as some scholars have recently explained, the prohibition expressed by the jurist Ulpian only concerns the prison in perpetuity with chains as a punishment inflicted to a freeman. Nevertheless, we have also to recognize that imprisonment was probably forbidden at the time when Ulpian wrote, even if in practice it existed as a sort of punishment per se, due to the bad habits of the governors of the provinces. Yet, from the time of the late Principate onwards and at the time of the Dominatus, the emperors began to, in their own constitutions, began to deal with the punishment of prison and imprisonment. So we actually cannot consider Roman law as a crystallized, from a crystallized perspective. Roman law went through a long development over the century. And so if we want to have a look at Roman law sources at the time of the Dominatus, late Principate and Dominatus, we can simply argue that in some cases the prison was conceived not only as a preventive measure, and in some other cases it became a replacement for other punishments. For example, a replacement for the punishment to the forced labor in the mines. So prison in ancient Rome was not only considered as a kind of custody, as a preventive measure. So the rule described by the jurist Ulpian out of its original context and the other rules enacted by emperors concerning the possibility to apply imprisonment as a kind of punishment has not always been analyzed in depth. And in this way, only focusing on the formal meaning of the text written by Ulpian that I quoted before, so the paragraph 9 that I read already twice, so only focusing on this, on the meaning of these few lines, a kind of vulgata, a kind of firm opinion has developed in the Western legal tradition. So, for example, just to make a few examples, the very well-known Italian jurist Bartolus, in his commentaries on the Codex Justinian, described the prison only as a preventive measure, adopting thus the perspective of the adopted by Ulpian. In some way, Bartolus fixed a kind of principle, a kind of dogma, and it was created, this kind of dogma was created out of the words written by Ulpian. Bartolus affirmed that the condemnation to prison for life was forbidden de jure nostro, so according to Roman law, that was the basis of the so-called European jus commune. Yet, the same Bartolus admitted that exceptions to this principle existed in practice. Indeed, Bartolus wrote that the damnatio to prison for life was to be considered a capital punishment, that this kind of punishment led to servitus penalis, so he reused the concept of servitus pene, and finally, Bartolus wrote that the damnatio to prison for life was similar to the ancient damnatio in metalla of the Romans. So the carcere in perpetuum, the prison in perpetuum, forever, prison for life, was therefore indirectly accepted as an alternative to other punishments. A few years later, for example, Baldus de Ubaldis, I quote the text in my handout. Where is it? Yes, text number 8. Again, quoting Roman law, Iure Nostro. Iure Nostro means, of course, according to Roman law. A few years later, Baldus de Ubaldis reasserted the authoritative opinion by Bartolus. Nonetheless, to balance the rule derived from Roman law with the jus proprium, so the local rights of the different communities contained in the municipal statutes, Baldus had to admit that at that time, the existence of the punishment of prison for life was recognized by the local practices. So, in the case of the imprisonment of prison for life, as Baldus wrote, the prisoner was a servus pene. He was subjugated to the servitus penalis once again, like a convict to forced labor in the mines. And so we can easily find, in this case as well, echoes of the ancient Roman law. So what began to emerge also from the so-called practicae criminalis, so text concerning criminal law at the time of the Middle Ages, is a kind of dichotomy between the theory and praxis. The theory, as developed by the glossators, commentators, and so on, was connected to Roman law and was connected to the formal interpretation of the text by Ulpian that I read before. Yet in the praxis, the prison and prison for life was used and was conceived as a kind of punishment. Also for another reason, because in canon law, at the same time, the punishment of prison developed as the main and the most important alternative to the death penalty for the clergyman. Later on, the humanist Cujacius in the 16th century AD commented once again the text by Ulpian by adopting a very a philological approach to the text. And according to the French jurists, it was to be confirmed, the interpretation, according to which the prison could be only used as a preventive measure. So in this case, in the case described by Ulpian, according to Cujacius, the Roman jurists simply described an abuse, and the abuse of the governors was against the rule that already emerged in Roman law. So the sentence by Ulpian was to be taken as a model according to Cujacius. Even if the same Cujacius admitted the actual fact that in the praxis, the theoretical principles created on the basis of Roman law had been overtaken by the practical use of prison, and prison also for life, as a punishment. We can also appreciate this kind of point of view in the text that I quoted by Thomasius. So if we have a look at Thomasius, for example, Thomasius explains in this text that is a comment to the digest, so part of the comment of a comment to the digest 48.3, notat singulus institutionem pandectarum titulus by Thomasius. Thomasius asks why there was a degeneration of culture that became a pena, that became a punishment apud nos, so in Germany, in our times. So Thomasius simply recognizes that there is a principle deriving from a certain interpretation of Roman criminal law, a certain interpretation of the text written by Ulpian, And there is a difference between the theoretical elaboration and then the practical application of the penalties, once again. And the same Grotius describes the servitus, and so the kind of slavery, as servitus perfecta, and the servitus perfecta is modeled on the Roman idea of servitus pene. And the servitus pene is a kind of servitus of slavery that deprives the convicts of freedom. And so Grotius still re-elaborates the Roman concepts of capital punishment and the Roman concept of the loss of freedom. So I'm about to conclude, but first I would like to make a few final remarks. So in the 16th and 17th century, in particular, the jurists still perceived this kind of legal ostensible rather than apparent this kind of dichotomy between the depiction of Roman law that they had in mind, and so the theory and the principles based on the idea of Roman law that they had in mind, and the law existing and effective in the praxis at their time. Furthermore, many scholars at times affirmed, it is the case, for example, of Francesco Casoni in Italy or Francesco Maradei in the 18th century, that prison could be compared to torture. So it was necessary to avoid the use of prison as a punishment because the inhuman living conditions of the prisoners were comparable to the conditions of the convicts put to death. There was therefore a kind of moral tension that characterized the way of thinking of many legal scholars between the 15th, 16th century and the beginning of the 19th century. In any case, it was pretty clear that prison as a kind of punishment had already emerged over the previous centuries. So either in praxis or as officially recognized as it happened, as I told you before, in canon law, where prison was used as a surrogate for the death penalty. And therefore, in many ways, we can appreciate how the concepts deriving from Roman law were used to defend some kind of affirmation, were used to legitimize some kind of affirmation against the use of prison as a kind of punishment. Yet in the praxis, many different kinds of punishments, like prison for life, were applied to the convicts. But final remarks I would like to do are the following ones. So what kind of Roman law was interpreted? So which was the interpretation of what kind of Roman law in the Middle Ages? Because the interpretation given by the scholars only focused on the text by Ulpian, whereas some other texts concerning, for example, the servitus pena were used to justify and legitimize the idea of the death penalty or of different kinds of punishments. The fact is so that Roman law in many ways was used to define and legitimize some kind of legal concepts and theories on the one hand, whereas on the other hand, the models, the practical models, the practical punishment used by the Romans were used as an example to create different kinds of punishments over the centuries. In this sense, I would say, of course, there is no continuity between the punishments applied by the Romans at their times and the punishments applied over the centuries in the Western legal tradition. Of course, also because Roman law was not the only source of law at the time. Yet, I would say that in any case, Roman law was the main example the scholars had to confront themselves with. And so Roman law represented the model used either to legitimize the use of prison or to delegitimize the use of prison. But in any case, they couldn't find the different kind of all these kind of different punishments in the examples offered by Roman law. And when we have a look at famous work by Cesare Beccaria, dei delitti e delle pene, still we still have to consider that Beccaria, for example, in the chapter 28 de la pena di morte, Beccaria affirms that, of course, the death penalty had to be abolished. And he affirmed not only that the death penalty had to be abolished, but also that it had to be substituted by the prison and, in addition, the forced labor. And this idea, of course, became very popular. And according to Beccaria, it was something completely different. So it did not look, so he said that it did not look at the models offered by Roman law because Roman criminal law was somehow barbaric. Yet, when we think at the idea of the concept of the legal reasoning behind the idea of prison and forced labor, it is pretty clear that the same Beccaria, the ideas of the same Beccaria lie in this kind of tradition deriving from Roman law, deriving from a re-elaboration of concepts already emerged in Roman law. So I would like just to finish, with some brief remarks. The point is that Roman law, of course, can be used and reused, as I told you before, either to legitimize or delegitimize some ideas and some concepts. And it is clear, as I hope that I have showed in my very brief lecture and presentation, that we cannot simply try to find a continuity in the repressive systems and try to find a continuity deriving from Roman law and up to modern times. It's impossible, it's nonsense. Yet I would say that what we can find behind the development of the idea of prison in the Western legal tradition, the legal reasonings, the purposes, the concepts behind the creation of this punishment that is nowadays so important to the Western legal tradition, legal reasonings and concepts can somehow be related to a reinterpretation or a misinterpretation of Roman law. In any case, legal scholars had to confront themselves with the experience derived from the time of the Romans. The concept, as I told you before, the concept of capital punishments were in this sense seminal and essential to the creation of several different kinds of punishments over the centuries and to the development that led to the creation of prison and, in addition to prison, forced labor. Even if, of course, in many cases, Roman law was taken as an example either to take the distance from or as an example that could be not used any longer in European legal history. Yet, many concepts developed over the centuries in the Western legal tradition, according to my opinion, found their roots in the development of the capital punishment in ancient Rome. Thank you very much. Thank you for your attention. And sorry, but being online is not that easy, in particular if you have to show some sources. But I hope that what I said was enough comprehensible. So thank you very much.
Thank you very much. So now the floor is open for questions, both for people online and in the room. Just a note to people in the room, please turn on the closest microphone when you're speaking, because without that, the people online won't be able to hear you. So does anyone have any questions? Go ahead.
Victoria Salatin, University of Warsaw. You said that you made a remark about the continuity And I do find a continuity, but in another way. I do find a continuity between my own presentation and your lecture. So I won't be addressing any comments as to the merits, just not to spoil. I just wanted to make one remark more than question, that it's very nice to see that someone actually does not underestimate the criminal law, because what you said earlier, there is a tendency, like it's not a growing tendency, it's always been there, but even among modern scholars, modern Romanistic jurisprudence, Romanistic doctrine, there is a tendency to say that the private law is the Roman thing, and the criminal law not very much. So it's very nice to see you again and be able to hear about your remarks on Roman criminal law, because I really find it as interesting as the private, and even the aspect that it's not so much touched by the doctrine. It's even more exciting, let's say, for a legal scholar to just explore. Thank you.
Thank you very much for the remarks. And well, you stressed a very important point, according to my opinion. So the fact that Roman law scholars constantly focus their attention on Roman private law. So the Western legal tradition is only a tradition concerning only private law, and I think it's not correct to affirm that for a couple of simple reasons. First of all, I don't believe in the dichotomy private and public in Roman law, because there was not this kind of distinction. So we find this distinction in Roman law because we have the dometic approach derived from the 19th century, and so we want to find public law and private law in Roman law, but it was not like that for the Romans, as far as we know. And secondly, it is pretty clear that if we want to find the continuity, like in the case, for example, of sale and hire, well, we don't find that in criminal law, of course. Well, sale and hire in the BGB as modeled on the Roman model, of course. But we could say a lot about sale and hire. But for example, equilibrium liability and so on and so forth. Equilibrium liability in Italy is really modeled on the Roman model. Yet, the influence of a legal system of the past on the legal systems of the following centuries is not only connected to what we directly inherit from the past. It's also connected to legal ideas, legal issues, legal needs, social needs, and the attempts to answer to different social and legal issues. And if we have a look at the Romans and at Roman law, we can easily comprehend how the models and the answers that Romans tried to find to the question why punish were so important and so seminal in the Western legal tradition as well. And this is the case of prison, I would say, because the Romans wanted to marginalize or to put some people, some convicts away from the social group by creating the addictio, the sacertas, the exilium, and then the servitus pena, and then the deportation, and so on and so forth. And imprisonment, in many ways, played this role also in the following centuries, and not only imprisonment. So all the elaboration concerning death penalties and servitus penalis in the Middle Ages was based on the Roman texts, even if the practical answers were different than the answers that the Romans gave to the same legal questions and legal issues. Of course they were different because societies were different, political situations and conditions were different. Yet we were somehow legally and culturally influenced by the Romans, even if there is no continuity. I don't believe in the myth and the dogma of the continuity, but this doesn't mean that there is no influence at all. So I hope that.
So just a very quick ad bottom. So it's actually about sharing not the analogical institution, but the analogical ratio legis that stands behind creating the institution.
It's, yes, something concerning ratio legis, something concerning principles, something concerning aims, because of course the repressive systems tries to intend to get to some aims, to some goals, and this is another point. So the ratio legis is of course one of the point that we have to focus on, but it's not the only one, I would say. It's also cultural question. So I'm not that kind of fan of Agamben's theories on Homo sacer. I don't believe Agamben is right. So it just makes anachronistic comparisons. Yet it is true that in different societies, in different periods of the history of the Western tradition, there has been the need, the attempt to marginalize people. So, just to make an example, the case of the werewolves in the 15th and 16th centuries, or the case of the witches, or some other cases. I'm not such an expert, but just to make some examples. So the need to punish and marginalize some elements, some conflicts, was present at the time of the Romans, it was present later on. And of course, when we had to legitimize an opinion, we tried to refer to the most authoritative historical examples that we have, or at least it was like that in the past. And Roman law was the most authoritative reference that legal scholars had in the Middle Ages. So this worked both for private and for public law. So, of course, things change, times change, and the answers nowadays cannot be the same as in the past. So we cannot apply any longer the damnatio ad gaudium to anyone, unfortunately. But still, the need to punish someone, why to punish, how to marginalize somehow people, these kind of issues are always present in the history of societies.
Thank you. Professor Zeman had a question, and after that, Fyodor online, and Professor Polet, right?
A short question concerning the importance of imprisoning. Is it possible to recognize the importance of the sanction of imprisoning? I'm asking because, you know, this sanction, there must be big preconditions. You need an infrastructure. You need prisons. You need a lot of people guarding the imprisoned people. A very demanding infrastructure, and in modern times this didn't exist actually before 1800. So it was not, you couldn't executing imprisoning in Middle Ages because just nothing like such an infrastructure. So I ask, in the antique, can we recognize if in the antique did exist, for example, prisons and people who are guarding on the captured people? Do we find this in the antique? Because this is an unavoidable precondition for having this kind of penalty.
May I answer?
Yeah.
Okay. Yeah. Thank you, Professor Zeman. Thank you very much. This is a this is a very important question, of course, and thank you for the question. So I just focused for a moment on Rome, on ancient Rome, and I could say that according to the sources, of course, there were some kind of prisons. So the Carcer Mamertinos, for example, some other carceres, and some other prisons existed in Rome, but there were not so many infrastructures. That was the first point why carcer was not used so often. And a second reason, so the Romans preferred, because they were very practical in this sense, they preferred to put someone to work in the mines instead that let someone in a carcer, because the mines are to be exploited, and the slaves and the convicts working in the mines were so essential to Roman economy. So this was the main issue. But when the mines were not as important as in the past any longer, or when in those places where there were no mines, okay, it was possible to let people simply stay in a carcer, in a prison, if there was this kind of infrastructure. At times, the carcer was a mine, or it could be a mine, by the way, in the case of the Lautumie, for example. But when there were no mines, people could be let in prisons, for example. There were two different problems. Who guarded the convicts? And this is something that Pliny, for example, discusses together with Trajan, with the Emperor Trajanus in his letters. So there were some kind of slaves, the servi publici, so the slaves of the city or slaves of Rome, who could be used to guard other convicts who were in the prisons. And I believe, so I didn't went through the exegesis of the text by Ulpian, but the text by Ulpian is so in the few lines, Ulpian says a lot of things. I think that Ulpian expressed this opinion against the carcer for the simple reason that some governors used the carcer, used the prison, because in their provinces there were no mines. That's the point. That's another point we have to take into consideration. And so they said, okay, we have no mines. Instead of sending the convicts to other provinces where the mines are, it was possible. But of course, it was expensive, it was complicated. So the governors could say simply, let's take these, let these convicts in the prisons that we have, or in places similar to prisons, and let's try to find someone guarding them. Coming back to the time of the Republic for a moment, so persons imprisoned but in custody, so in preventive, in the cases of preventive custody, were usually guarded by the tres viri capitales, so this kind of magistrates. But of course, the use of prison was not that popular at the time of the Republic. Also because citizens either accepted to be condemned to death and it was they were immediately executed, or they simply tried to escape and go away and leave Rome as soon as possible to avoid the death penalty. I hope I answered your question. Yeah.
Thank you.
Thank you.
Now, Professor Poloyets.
Thank you very much. This was very interesting lecture, and focus is obviously on imprisonment or prison. But I would like to ask something about this sanction of exilium. You explained very well this development from the early Aquae et Ignis interdictio till this change when it became really capital, a kind of capital punishment in the time of Principate. So I'm interested, you make the, there are two kinds, relegatio and deportatio. And deportatio is kind of stronger, harsher sanction, capital punishment. But if you read the text, then I'm not sure whether you can really clearly make a difference. Sometimes, for example, because in later times, deportatio was for lower classes and relegatio more for high classes of yes, delinquents, let's say. But in texts, I think it is not so much clearly, it is not so much clear whether somebody can have one or the other sanction. So I'm interested to, if you can explain more about that, and whether is it possible to say that exilium in general is like again is a general term for both kinds of also for deportatio and relegatio, and also whether is there any influence on criminal punishment of today of modern legal systems, this kind of sanction. And for only one remark at the end, of course, I very much agree with all you said about that starting point for any discussion in later times, starting from Middle Ages, was always Roman legal texts, either to legitimize or dislegitimize certain idea or concept, and also that there is no very clear line between public and private law. And also I would remind also on this very famous discussion on Lex Aquilia, in that sense, whether this was there was a reception or not, and all these different views on and usually those jurists of later times use only certain texts, particular texts, like, for example, this time, this Appian text about culture, and to make conclusions, and not whole digest in which there are so many different opposing and contradictory texts, and you can, of course, always choose what you think it is best to approve or disapprove your view. Thank you. Sorry if if it was too long, but.
Thank you, Professor. Thank you very much for the question. So, well, just to begin with your last remark, well, of course, it was a lot easy to epitomize a text by Ulpian and to take out the principle out of the text by Ulpian and out of the context in which the text by Ulpian should be put. So, of course, Roman sources gave this opportunity to legal scholars in the centuries, and it was also easy, for example, for Beccaria to say, well, Roman rules about criminal law were barbaric. We don't want to follow them, and then to suggest we can use imprisonment and in addition forced labor as an alternative, as a more civil alternative. Yet it is clear that Beccaria simply wanted to follow a kind of vulgata, a kind of traditional point of view that was useful to his purpose. It's pretty clear. So the idea of epitomize the text of the jurists, of the Roman jurists, or the text of the sources of Roman law, in order to legitimize or delegitimize modern concepts, well, of course, it's been used in several different ways. I try to come back to your first question, so concerning the differences between relegatio and deportatio. Yes, I know the casuistic is not that easy. I mean, in some cases, it's really clear that they overlap somehow, so there are overlappings, and it's not easy to distinguish whether it is a case of relegatio or a case of deportatio, in particular if a person is sent to an island. If the convict is sent to an island, it would be either a deportatio or a relegatio. I think that we can distinguish them only if we have some other information, for example, concerning citizenship. Because if there is the loss of citizenship, this should be deportatio. Whereas relegatio, in theory, should not lead to this kind of effect of consequence. Yet it is true that from the 3rd, 4th century AD onwards, there is almost no difference any longer between the two. So still in the Pauli Sententiae we find used the word deportatio, but the relegatio is not any longer important. So it's true what you stressed. I somehow oversimplified the description only because the history of relegatio and deportatio is that so long that well, I usually spend 2 or 3 hours in my courses at the university only to explain the main features of the two kinds of punishments. So I agree with you about the problem of the development and so the overlappings between the two kind of punishments. And the other question concerned the exilium, if I'm not wrong. Well, I would say that yes, this is my opinion. This is actually my opinion because I know that there are several different opinions. And for example, in Italy, there was this huge discussion between Santa Lucia and Crifo, and in Germany there was Grasmuck, and so there has been such a big discussion on the development of exilium and whether deportatio and relegatio are the development or the exil represent the development of exilium or not. According to my opinion, they represent the development of exilium. The Romans at time, the Roman jurists at times used the term exilium to refer to either relegatio or deportatio. But it's not only a question of terminology, I would say. So it's really a question of the development of the repressive system of the Romans. So the exilium took the way that then was the way of the deportatio, that became the way of the deportatio and the relegatio. That's my opinion. Whereas the death penalty was simply the death penalty, so the convicts were beheaded at the time of the Republic, and then there were these several different other kinds of penalties that could lead the convict to the death, but according to the needs of the time of the Principate. So mines to exploit and something like that, and so the gladiatorial fights and so on and so forth. So I think that yes, deportatio and relegatio are let's say represent a kind of development of the concept of exilium. Yes. The, likely there was another question.
Well, I only asked whether there is some influence on modern
in modern
on
concept. Yeah.
modern law of punishment or
So to our days punishments, you mean modern days, our days punishments?
yeah, exilium is not so much. Yeah,
So
okay.
there is this different kind of idea of exilium, that is the political exilium, exile or something like that. Of course, it's a way to remove a person that is not.
Yeah, this is too far, I think.
But I find that a huge. I find differences between the two. Yeah. Yet maybe the idea could be similar, but I would try to distinguish the two different kinds of
thank you
exilium.
very much.
Thank you very much. Thank you.
We had an online question now. Do go ahead. We can't hear anything. You're muted. Please unmute yourself.
Can you hear me?
Yes, we can hear you now.
Okay, okay. Can you see me?
No, we can't.
Oh,
But hearing is the more important part.
okay, fine. I have a question for Professor Beggio. What are the arguments for reinstating the death penalty in modern times?
Sorry, could you speak louder, maybe? Because I
Oh, sorry.
can't, sorry, I can't
Oh,
hear you
sorry.
very well. Sorry, sorry.
Okay, okay. So here's my question. Here's my question. What are the good arguments for reinstating the death penalty?
Oh, you mean arguments to reintroduce death penalty nowadays?
Yes.
Oh, I personally don't find good arguments to reintroduce death penalty in modern times. I am against the idea of death penalty because, well,
But what are the best arguments, in your opinion, for reinstating the death penalty?
I may interfere. I think the colleague means what are the most convincing arguments of those
Yes.
who do support reintroducing
Exactly.
it?
yes, I understand, but I don't find them in the sense that I'm against the death penalty. So I don't believe that the death penalty would be a solution to any kind of for any kind of repressive system. So I don't find good reasons to try to motivate the reintroduction of the death penalty in any modern repressive system, legal system. So this is my opinion.
But what if, well, so what about, for example, criminals who want to commit a crime, they want to commit a murder, but then they think, well, if I get caught and I'm found guilty, then I'm going to be executed. And so the death penalty would then discourage somebody from committing a crime.
I don't believe death penalty has this kind of preventive effect any longer. And well, it's a question of opinions, of course. In my opinion, there are no good arguments to support the idea of reinstating death penalty.
But so, for example, in the United States, there are certain states that have the death penalty,
Yep.
and certain states that do not. Most states do not have the death penalty, but yet the United States has a very high murder rate, and it rarely ever executes people. We execute probably like, I don't know, 11 people a year or something like that. But if you look at a country like Saudi Arabia, which has a very, very strong death penalty policy, the murder rate of Saudi Arabia is lower than that of the European Union and lower than that of the United States.
Well, I think that the main problem is not the number of people executed or the number of murders or something like that. I think it's a question of democracy and also democracy in the approach to repressive systems. As I told you, I don't find good arguments to reintroduce the death penalty. Oh, but that's my opinion, of course.
Right. So somebody, let's say, for example, here in the United States, we had a guy by the name of Dennis Rader. Dennis Rader went into a home and he murdered an entire family. He murdered almost the entire family. The son came home from school and he saw his mother dead, his father dead, his sister dead, his brother dead, and Dennis Rader was arrested. Do you think that Dennis Rader deserves to be executed for murdering that family?
Once again, no, because I'm against the death penalty. So that's my point. I know that it's horrible what happened, and that there are horrible crimes. So horrible crimes take place every day, and unfortunately, I would say, but still, I believe that I'm against the death penalty. So the fact that I study death penalties in Roman law doesn't mean that I'm a supporter of the death penalty,
Okay.
because I'm actually not.
Okay.
But thank you.
All right.
Okay, thank you. Do we have any more questions? If not, I would like to thank Professor Beggio once again. Thank you for being with us.
Thank you very much. Thank you. Thank you.
We will now take a short break, 15 minutes, and then we'll continue with the first session on law and punishment in the classical antiquity. Professor Poloyats will be chairing it. So those who are present here, there's some coffee and tea in the room just to the left when you go out. Those who are online, see you in 15 minutes on the screen. Thank you very much.